I'm Raymond Johnson, and you're watching a special report. This is a show where we're going to bring to you hot legal issues and hot trials and discuss them for your viewing and for your consideration. Today we're going to talk about one very important trial that's taken place here in the state of Alabama, specifically down in Montgomery, Alabama.
Right.
And it's the case brought by the United States government against former Governor Don Siegelman and Richard Scrushy. And as a guest for you for this particular show is Julian McPhillips Jr. And Julian, you've been an attorney in the state of Alabama for over 30 years, about 36 years, if I remember.
Well, 32
correctly.
years back in Alabama since I returned in April of '75, and before that I practiced for 4 years on Wall Street. So if you add that together, it's a total of 36 years since I came out of law school in 1971.
So I imagine you have conducted and participated in many trials here in the state.
I certainly
and
have.
Outside the state.
I certainly have. Don't mean to be immodest about it, but you know, a lot of water over this dam.
Well, that's very good.
Thank you.
Have you been following this trial that took place in Montgomery?
I have, just as a citizen of conscience, first of all, but also because I happen to know Don Siegelman and Richard Scrushy, and I don't mind telling you that I've had a lot of respect for these guys, and so I followed this case with great interest. And to me, it's one of the worst miscarriages of justice I've seen in Alabama and the United States in a long, long time. It just stinks to high heaven, if you want to know the truth.
Well, and if I remember correctly, when I was picking up the newspaper and reading about it and listening to the news presentations in the evening after a day of trial, I thought, my goodness, this is something I could teach a law course on, the different issues that are coming up.
Well, you could teach a big law course about things not to do at practically every step and level of this case, things that should not have been done. And it just really offends me as somebody that believes that justice ought to be administered uniformly and fairly no matter what side you're on, whether you got the power or you don't have the power. It ought to be a level playing field. And this case was not played on a level field. There were a lot of problems with it.
Well, that's what I want to more or less go into, but maybe we ought to start and talk about what the actual charge was. In this particular case, it was a federal charge brought by the United States for bribery.
It was, and bribery requires something more than just, oh, I'm going to give some money to somebody for their campaign. I mean, of course, you know, there has got to be a real careful quid pro quo, and somebody needs to witness it taking place, and there wasn't any evidence like that in this trial. And also, even if they were convicted or convicted of what they were charged with, it wasn't a crime. I mean, he gave, Richard Scrushy did, money to a charity. And it was qualified as a charity, the lottery fund to raise money for public education. I mean, the lottery had it passed. The goal was to raise money for public education.
So it actually was not a campaign contribution for the governor's campaign.
No, it was not.
To be reelected. It
was not. In fact, it was for the lottery, but it was even after the lottery a referendum had been defeated. It was to help retire the debt. And, you know, it was a charity debt, and a lot of people, a lot of corporations out there, and their officers were helping to make contributions. The only one that got indicted for it was Richard Scrushy. And I just...
And this was the lottery to bring the lottery to Alabama, and
right.
It was defeated by the voters.
It was defeated by the voters, but Don Siegelman, whether you agree with the lottery, some opposed it. Scrushy did himself because he thought, you know, there's a little bit of a gambling aspect to it when you enter into a lottery. But however you felt about it, the ultimate goal was to help public education, a very laudable goal, and it would have if it had been passed. But anyway, it was defeated, and there was some debt associated with it, and that was the debt that Scrushy and a number of other people helped to retire by making some contributions to the fund. Now, it was not Don Siegelman's campaign, but if it had been Don Siegelman's campaign, ain't nothing illegal about that. In fact, hypocrisy is bad and it's full of hypocrisy in politics, but it's gross hypocrisy for the Bush administration through their U.S. attorneys to indict somebody for this when Bush himself is seeking $100,000 contributions to his campaign for president, and he gives ambassadors jobs here and there around the world that make those kind of big contributions. And so, you know, it's just gross, rank hypocrisy, and they all know it, and it should never have happened. It just...
Well, if I remember correctly, also in this particular case, the government charged that there was a $500 payment by Richard Scrushy to Don Siegelman for the purposes of being placed upon the con board. What
Well,
is a con board?
Well, $500,000 rather than 500, but in two halves. One came from HealthSouth, the other from somebody else up north that apparently was a friend of HealthSouth, friend of Scrushy's. But the con board is a certificate of need board, where the word con, C-O-N, acronym for certificate of need, has nothing to do with regulating hospitals, regulating or rules for it. It has to do only with expansions of hospitals.
Existing hospitals?
Yeah, existing hospitals that may have a need to expand. And Scrushy had been on this board under